Hello, everyone, and welcome to today's analysis. Today, I'm discussing the position of the law on appointment of commissioners. Recall that recently the governor of Akwa Ibom dissolved his cabinet, and it is expected that he's going to reconstitute the cabinet by appointing new names into the cabinet. Now, what is the position of the law as regards the appointment of commissioners? The appointment of commissioners is regulated by the Constitution of the Federal Republic of Nigeria. That means that the governor of a state cannot decide to work alone. He has to work with commissioners. Why? Because the Constitution says that he has to. He has no discretion but to appoint persons into the cabinet to assist him in the day-to-day running of the affairs of government. Now let's look at the provision of the Constitution as regards the appointment of commissioners, the qualification, the disqualification, and what the governor is expected to take into consideration in appointing commissioners. That section of the law is section 192 of the Constitution of the Federal Republic of Nigeria. What does it say? It says that the governor shall have the right to appoint such number of commissioners as the governor may decide. Have you seen this section? It says, as the governor may decide. So, this leaves it at the discretion of the governor. The implication of that is that, let's assume that the cabinet just dissolved, had 30 commissioners. The governor has the right to constitute the new one with 40 or 50 commissioners or even 60 commissioners if he has the capability to take care of them, to pay them, and create offices for them. The law allows the governor the prerogative to decide the number of persons to be made commissioners in his cabinet. Why? We go back to the language of the Constitution. It says, such number of commissioners as the governor may decide, right? It also means that the governor can decide to reduce from 30 to 10. He may also reduce it to 20 from 30. If he does that, he is still working within the provisions of the Constitution because the Constitution leaves it exclusively at its own discretion. What else has the section said? This same section says that upon the constitution of the names of persons to be appointed as commissioners, the governor shall send such names to the House of Assembly for screening. So it does not just end with the governor making the appointment. The governor has a legal responsibility to forward the names of the persons appointed to the Speaker of the House of Assembly through the clerk for screening and possible confirmation. The section also says that in appointing commissioners, the governor should not appoint people from one or two local governments or three local governments and neglect others. And that is why that section says that in making the appointment, the governor shall consider state character. That is the spread. We've been hearing of national character, federal character. The Constitution, as regards the appointment of commissioners, has made mention of state character. That means Akwa Ibom has 31 local government areas. When the governor is making the appointment, he has a legal responsibility to spread it across the 31 local government areas of the states. If the appointment is concentrated in 1, 2, 3, 4 local governments to the neglect of the others, that will be a violation of the Constitution. Why? Because the state is owned by all these 31 local government areas, and therefore, in making the appointment, the governor has been given a responsibility in the Constitution to ensure that there is a state character consideration in the appointment. What else has this section said? The section also says that no person shall be appointed as commissioner unless he is qualified to be elected into the House of Assembly. So that means that the benchmark for appointment as commissioner, as regards qualification, is that the person must be qualified to be elected into the House of Assembly. It then begs the question, what is this qualification? What is the requirement of the Constitution for someone to be elected into the House of Assembly? One, the person must have at least school certificates, right? So that means anyone that has finished elementary 6, or has moved up to secondary school or has any other qualification lower than that, right? By the Constitution of the Federal Republic of Nigeria, that person is qualified to be elected into the House of Assembly and therefore qualified to be appointed as commissioner. But any governor who appoints someone that doesn't have the requisite educational qualification to man a ministry, that governor is doing so at his own discretion. And if there's any risk taken by that decision, it is the governor that has taken the risk. But the Constitution says that the person must have at least school certificates. The second requirement is that the person must be a citizen of Nigeria by birth. That means that the governor cannot appoint a Ghanaian into the cabinet of Akwa Ibom as commissioner. It therefore means that the person cannot, the governor cannot appoint somebody from Burkina Faso or from America, no matter his expertise, to come and be a commissioner in Akwa Ibom State because the Constitution says no. The third requirement is that the person must be up to 30 years of age. That means that anyone that is 30, 31, 32, and above can be appointed into the State Executive Council as a commissioner. And it's not a new thing. In Cross River State, we have seen younger persons, people within 30, 31 being appointed into the cabinet. We've also seen in other states of the Federation. And in Akwa Ibom, it can also be done because the law allows the governor to bring fresh blood into his cabinet, younger persons into his cabinet. And if that is done this time around, the governor is not in any way offending the Constitution of the Federal Republic of Nigeria. Now, there is another issue that you have to take note of. The person must not belong to a political party before he can be appointed as commissioner, right? So, whether you belong to a political party or not, the governor has the rights. The governor has the permission of the Constitution to appoint you into his cabinet if he finds you worthy. So you don't need to belong to any political party whatsoever. You can just be a lecturer in the university doing your work. You can just be a farmer, but you are qualified by the Constitution. You are up to 30. You have at least a school certificate. You can be appointed. You can just be a trader. You can be anybody, right? Without belonging to a political party, you are qualified to be appointed as a commissioner in the state. It is all left to the governor to decide. The person must not be from Akwa Ibom State. So, provided you are a Nigerian citizen, that's the only qualification as regards where you're from. Provided you are a Nigerian citizen, you are qualified to be appointed into the State's Executive Council, right? So the governor can decide to appoint somebody from Katsina State, can decide to appoint somebody from Abia State, neighboring state to Akwa Ibom, can decide to appoint somebody from Owerri, from any part of the country whatsoever, provided he's a Nigerian citizen, the governor can appoint him into the State's Executive Council. The other question would be, who are the persons that are not qualified to become commissioners? The first person is that the person that is an undischarged bankrupt is not qualified. Because if you appoint an undischarged bankrupt, the person is already bankrupt, and therefore, he is very likely, as soon as he enters office, the first thing he's going to do will be to pack all the money to revive himself financially. So an undischarged bankrupt is not qualified to be appointed as commissioner into the State Executive Council. The person must not be a criminal. You'll be taking serious risk as governor to appoint a criminal, a known criminal, into your cabinet. The person must not be an ex-convict. At least within 10 years, no, anybody that has been convicted by a court of law of competent jurisdiction within 10 years would not be qualified to be appointed into the State Executive Council as commissioner by His Excellency, the governor. That's it on this edition of these analyses. I do hope you have learned one or two things. Drop your comments in the comment section so that together we can pick it up and then discuss even more about the issues of law surrounding the appointment of anyone as commissioner into the State Executive Council. If you have not yet subscribed to my channel, please click the subscription button so that you can be a part of this platform where we are ready to discuss everything of interest. Many thanks.